Dear colleagues and guests who are present here today and who are present here online, I would like to say that we are very sorry for the technical difficulties. But as you can see, the dissertation board is not to blame here. Let me declare the session of the dissertation board open. We're beginning the session for the defense of the Thesis by Maria Rozhdestvenskaya. The Thesis is submitted in conformity with the requirements for the academic degree of the candidate of science in law. The specialization is 120010 International Law, European Law. The topic of the thesis is International Legal Regulation of Classification Societies, Limitation of Liability. We kindly ask you to switch off your mobile phones. Let me inform you that the panel session of the dissertation board is being recorded and broadcast on the internet, on the official SPBU website. The session is being interpreted into English and Russian. Under the federal law, as of the 23rd of May 2016, on St. Petersburg State University and Moscow State University are entitled to confer academic degrees. The degrees are conferred only within the scientific specializations and branches of science specified by the Russian Ministry of Science and Education. The corresponding order on the procedure of granting academic degrees at St. Petersburg State University was issued on the 1st of September 2016. Let me remind you that the panel session of the dissertation board for the defense of candidate and doctoral dissertation is valid, providing 2/3 of the appointed board members are present. The total number is not to be fewer than 4 people. The dissertation board today consists of 5 people. They are all present, including 2 board members who are attending the defense remotely via Skype. Therefore, we have a quorum. According to Clause 9 of Section 4 of the above-mentioned regulation, the agenda is as follows. The panel discussion cannot exceed 2 hours. Accordingly, I kindly ask all those taking floor to keep within the time limits. I will specify that later. So, today we have the thesis by Maria Rozhdestvenskaya. It's submitted in conformity with the requirements for the academic degree of the candidate of science in law. The thesis was submitted for defense to the Center of Expert Advice on the 2nd of October 2017. The dissertation board members are Lyudmila Galyanskaya, Chairwoman of the Dissertation Board. Valentina Talimonchik, Doctor of Law, Associate Professor of the Department of International Law at the St. Petersburg State University. Olga Makarova, who's sitting to the left of me, Doctor of Law, Associate Professor of the Department of Commercial Law at St. Petersburg State University. Galina Shinkarevskaya, Doctor of Law, Principal Researcher at the Institute of State and Law of the Russian Academy of Sciences. Dr. Hannu Honka, Doctor of Law, Professor of the Department of Law, Abo Academy University, Turku, Finland. Добрый день. The candidate has submitted the following documents to the SPBU Center of Expert Advice. An application to the SPBU Rector, a report of the academic supervisor, list of published works containing 9 items, letter of verification that she has passed all the exams in her postgraduate course, expert statement on submitting the thesis for defense as an extract from the minutes of the meeting of the Department of International Law, a copy of the university diploma with honors issued by St. Petersburg State Maritime Technical University, thesis in Russian and English. All the above-mentioned documents comply with Clause 12 of Section 3 of the procedure on granting academic degrees at St. Petersburg State University. Are there any questions about the submitted documents? There are no questions. Now let me give the floor to the candidate. You have 15 minutes.
Good afternoon, dear Chairwoman, dear members of the Dissertation Board, and dear guests. The topic of my thesis is International Legal Regulation of Classification Societies, Limitation of Liability. Nowadays, the institution of classification society is a crucial component of safe maritime navigation. These organizations check the compliance with the international conventions, technical standards, as well as their own rules during the design, construction and maintenance of ships. Therefore, classification societies contribute to accident-free operation, safety of life at sea, safe carriage of goods by sea and environmental protection. Ports authorities, insurance companies, cargo owners, charterers and other parties take in account the results of their surveys. And classification societies can be delegated certain functions on behalf of the flag state administration. Casualties are not rare when a ship is being operated, and if the accident is caused by the technical deficiencies of the vessel, the question arises as to whether the classification society should be liable for it and to what extent. And the issue of unlimited liability of classification societies has become a debatable and irrelevant one. First of all, under international treaties, classification societies cannot limit their liability, and they are not included in the scope of persons who are protected against third-party claims. However, other parties, including ship owners, employees, agents, rescue workers and others, are entitled to this right. Secondly, flag state administrations conclude agreements with classification societies, and they may include a provision envisaging that while performing surveys on their behalf, classification societies are subject to unlimited liability for simple negligence. As a result, the work of classification societies involves substantial risk, and classification societies cannot obtain full liability insurance since there is no upper limit of liability. The Russian doctrine has made some research into this issue, but they are very limited. However, we think that this issue is quite relevant because Russian classification societies perform their functions at an international level, and a large number of fleet carries the Russian flag. However, classification societies cannot limit their liabilities. The scientific novelty of the thesis is as follows. The thesis presents a complex analysis of the specific aspects of legal liability of classification societies. The author has given a definition of the term classification society and has systematized and classified appropriate international treaties and domestic legislation. The thesis also contains proposals and recommendations for the improvement of international legal regulation and domestic law in their appropriate field. Now I would like to say a few words about the main research findings. So there is a need to establish a balance in the field of liability or limitation of persons engaged in merchant shipping. At the moment, classification societies are not entitled to limit their liability. However, other parties, like ship owners, can limit their liability. Besides, there is a contradiction between the limited liability of the ship owner who is responsible for the seaworthiness and the unlimited liability of classification societies, which only contribute to the seaworthiness of the vessel. Thirdly, unlimited liability of classification societies is not consistent with the principle of the liability channeling enshrined in the International Convention on Civil Liability for Pollution Damage. Under this principle, the ship owner is liable in the first place for causing the damage. Fourth, classification societies do not affect directly the safety of the ship, do not derive any profit from the operation of the ship. However, the fees for their services are not commensurate with the extent of potential risks associated with unlimited liability. So we have analyzed international treaties and the Russian legislation, as well as the legal status of classification societies, and we have given the following definition of the term classification society. So, classification society is an independent organization performing technical supervision and classification of ships and offshore units, and consequently issuing certificates confirming their compliance with its classification rules or provisions of international treaties on behalf of the flag state administrations. We also analyzed the possibility to invoke provisions of current international legislations. I mean legislations on limitation of liability. In general, classification societies cannot limit their liability in a way that ship owners and other parties can. However, classification societies can invoke the provisions of the International Convention on Civil Liability for Oil Pollution Damage. We also focused on the analysis of different instruments of limitation of liability of classification societies. We analyzed the possibility to amend the Convention on Liability of Liability for Maritime Claim 1976 and the International Convention on Civil Liability for Oil Pollution. However, amending current international treaties may be complicated by the need to reach consensus among the parties and may create different legal frameworks. We also analyzed possible amendments to the IMO Code of Recognized Organizations. However, this document regulates the actions of classification societies performed on behalf of the state. Finally, we have analyzed the possibility to limit the liability of classification societies, in particular by preparing either an international legal act on the unification of norms on the limitation of liability in the sphere of merchant shipping, or by preparing a special international legal act on the limitation of liability of classification societies. It seems expedient to develop, under IMO auspices, an international legal act that envisages common principles of classification societies' limitation of liabilities, which take into account public and private aspects of their activities. We must also say that we also focus on this twofold nature of classification societies. And irrespective of the type of the international legal act, the following aspects must be taken into account: irrelevance of strict liability, regulation of activities in terms of public and private interests, clear justification of the grounds and conditions for the occurrence of liability, balance of interests, and protection of the injured party, as well as liability limits commensurate with the potential damage. In terms of the upper limit of liability, provisions of current conventions on limitation of liability should act as underlying principles, since these conventions have already been ratified by the majority of states. We also delved into the following issue: whether classification societies may invoke immunity from jurisdiction when performing activities on behalf of the state. The object was to establish whether these actions are of private or public nature, and whether these organizations may be regarded as agencies that are entitled to perform and are actually performing acts in the exercise of sovereign authority of the state, under the UN Convention on Jurisdictional Immunities of States and Their Properties 2004. First of all, under the UN Convention on the Law at Sea, the flag states exercise their jurisdiction over ships flying their flags, which include statutory surveys of ships and confirmation of their compliance with the provisions of international treaties. Therefore, we see that under Solos and Marpol conventions, the state can delegate these powers to the recognized organizations, in other words, to classification societies. However, the state should be responsible for the proper performance of these works. Certificates, even when being issued by recognized organizations, should be regarded as having the same force as the ones issued by the state. The above stated reasoning allows us to conclude that classification societies, when performing activities in public interest, are entitled to perform and are actually performing acts in the exercise of sovereign authority of the state. The argument is substantiated by the provisions of the IMO Model Agreement, which states that performing its statutory functions, classification societies may use the same legal protection as the state, as if it had performed these functions itself. Court cases confirm these findings. For example, we can refer to such cases as the case of the Erika tanker. As a result of this accident, there was an oil spill which damaged the area. When Rina was regarding the case, the court came to the conclusion that we cannot regard giving certificates as a public service, and according to the court, Rina could invoke jurisdiction of immunity. And another case I'm referring to is the Sundance case. The American Classification Society was accused of giving the certificate inappropriately. However, the court referred to the appropriate legislation, according to which each person could invoke immunity if the works were performed properly. The above mentioned allows us to make a conclusion that under the UN Convention, classification societies can invoke immunity from the jurisdiction in courts of other states. However, until the Convention of 2008 comes into force, this issue will be resolved according to the national legislation and common law. Federal law number 297 about jurisdiction immunities of the foreign state and property of the foreign state in the Russian Federation was adopted. The law is similar to many provisions of the UN Convention 2004. For example, the law gives the same definition of the term foreign state. However, the law also has some differences. Article 16 says that the state cannot invoke immunity from the jurisdiction if the state is the owner of the ship, or if the ship is operated for other purposes than government non-commercial purposes. The immunity can be invoked in relation to ships of war, supplementary ships, and other ships owned by the state or operated by it for non-commercial purposes. And the term operation is not defined in the Convention. However, the law stipulates the following, that the operation of ship implies supply, maintenance, and other works and services related to the ship. Therefore, in this interpretation, statutory surveys can be covered by the term operation of the ship. However, we believe that statutory surveys and issuing of certificates of compliance performed by the states or classification societies on their behalf should not be covered by the term operation of the ship, since these activities are related to the state sovereign prerogatives and they are not the same as maintenance works or different other services. The author highlights that this interpretation of the term is inconsistent with the international documents and court cases. Should Russia ratify the UN Convention of 2004, and if it comes into force, the law will contradict international obligations of Russia in terms of the extent and conditions of the immunity given to foreign states. To avoid this, the author proposes to bring in line the provisions of the law with the provisions of the Convention and add the provision which allows to invoke jurisdictional immunities if the services were connected with the sovereign power of the state. I would like to say a few words about the theoretical and practical relevance of our thesis. Our findings can be used for further research and can be used to develop training courses and lectures, as well as the findings can be used in law-making practice as well, and the research findings may also be interesting for ship companies and classification societies. Thank you. Thank you. You almost kept to the time limit. Are there any questions to the candidate? Please ask your questions in relation to the presentation just given. If there are no other questions, I must say that we have received reports from all the members of the dissertation board. The report on the thesis was submitted in due time, as is stipulated by the appropriate order of St. Petersburg State University. So let's move on to the reports. First of all, I would like to say that we have a strict agenda. The time limit is 10 minutes. Your reports on the thesis are posted on the official website of St. Petersburg State University. So I think 10 minutes is enough to give your impression of the thesis. Since I'm the chairwoman here, I would like to start.
So let me share my impression on the dissertation presented by Maria Rozhdestvenskaya. I will be keeping within the time limit strictly. First of all, I'd like to say that the topic is relevant. The issue has been little studied in Russia. I suppose that the topic itself is really interesting, both theoretically and practically. So it was logical that Maria Rozhdestvenskaya decided to tackle this issue. The structure of the dissertation is traditional. It comprises introduction, 3 chapters, and the conclusion. The candidate has been really logical to unfold all the issues, starting off with some general issues, then focusing on more particular issues. What I really appreciate about the dissertation is that the author has made a deep analysis of relevant research papers and works. She has conducted a really logical analysis of all the sources. She supports the analysis by no less relevant conclusions. What I accept in Chapter 1, that classification societies are not only acknowledge the seaworthiness of a vessel, but not liable for their condition. In general, the candidate has really fulfilled the task. The topic is well presented. It's interesting. However, I have a few remarks to make. I'd like to focus on the remarks in depth. In section 1.1, the author focuses on the legal status of classification societies, and she provides her own definition of what a classification society is. A classification society is an independent entity performing technical supervision and classification of ships and offshore units, and consequently issuing certificates confirming compliance of ships and offshore units with its classification rules, or issuing on behalf of the flag state administrations certificates of compliance with the provisions of international treaties. It's obvious that this definition contains the following. A society is defined through the word organization, which I find inappropriate from a legal viewpoint, because the candidate doesn't actually state what she means by the word organization. So I can't accept this definition, and as the candidate used this definition, so using this definition, the candidate hasn't actually defined the legal status of such societies. The second remark is that the dissertation really has a gap in its contents. The candidate has focused on the activity of classification societies only within such regional institution as European Union. She doesn't make any mention of other regional organizations. There isn't a word about other regions. I'd like to add that this is what we often witness in academic writings. I have a feeling that there are no other regional organizations apart from the European Union. And finally, my critical remark number 3. I'm really against the use of the term major principles. We find that in the finding of the research number 4, and then it's used further in the dissertation. The point is that this term in international law is used to define imperative, general, to describe general and imperative criterions, which were specified in the UN Charter and the Declaration on Principles of International Law, and such rules as the irrelevance of the strict liability, securing balance of interest, and other terms that the candidate offers as the basis to develop an international legal act. All these terms don't have these qualities, and I dare say we can hardly refer them to the category of principles. Despite the critical remarks that I have made, I believe that the dissertation is in conformity with the major requirements set forth in the order on the procedure of granting academic degrees at St. Petersburg State University, and Maria Rozhdestvenskaya can be awarded the academic degree of the candidate of law. So I have really managed to keep within the time limit of 10 minutes. So now the floor is given to Galina Shinkovetskaya to present her report on the thesis.
Thank you very much. I must say that this thesis is very interesting in a way that it demonstrates a new approach to defining many legal phenomena. The thesis speaks about the liability of a legal entity for the actions that it performs within the framework of the national law, but the consequences refer to international relations. Therefore, the object of the thesis is an intricate intertwining of international liability of the state, of different powers of the authority, and the actions of a legal entity under the national legislation. That is why we can say that it was extremely difficult to collect material for the analysis and perform the research work. But I must say that the candidate and the research supervisor were able to perform this analysis. The thesis is extremely coherent, clear. I must say that the data collected for the analysis is enough to analyze the issue. Here I would like to highlight that the candidate used doctrines as well. Very often candidates use quotations just for effect, but this candidate refers to different works, books, either to clarify the issue or to confirm or to refute some opinions. I would like to say that the candidate uses the terms which are well known and well accepted. However, she limits and clarifies these terms. Here I mean such terms as limitation of liability, page 62, or liability channeling, page 87. And the candidate also assesses the legal status of different parties of marine shipping and their rights. One of the most difficult aspects of this topic is the combination of public and private aspects of the actions of classification societies. Here I agree with the candidate's opinion that their activities can be regulated efficiently by signing a special international treaty. Unfortunately, I also have some critical remarks. There are some places in the thesis that require clarification, and it refers to the definition of the classification society, which is given in research finding number 2. The author identifies classification societies as the entity, but I think she should have identified their status within the system of international cooperation, and she should have highlighted that these organizations act on behalf of the state, although they are not an organization. I must say that the author proposes to bring the provisions of Federal Law 297 in line with the provisions of the United Nations Convention on Jurisdictional Immunities, and I agree with the author. The candidate writes that classification societies must be able to invoke jurisdictional immunity, but I think she should have clarified this idea more clearly. But in general, the thesis has very high scientific value, and it confirms with the requirements set in order on the procedure of granting academic degrees in St. Petersburg State University, and Maria Rozhdestvenskaya should be awarded the academic degree of the candidate of law. Thank you very much for your report. Now the floor is given to Professor Honka.
Acceptance. However, this acceptance is not without certain criticism of the thesis itself. I will not go through all the aspects in my written statement because it's fairly long, but if I may take up some major issues, also remembering that I'm a civil law person, and that's why I focus very much on the liability issue itself. What is the liability in damages, and what are the preconditions for that liability concerning a classification society? And I would say that my major observation as to the thesis is that the doctoral candidate starts with more or less stating that a classification society should have the right to limit its liability. And this statement is given before there has been research on what conditions a classification society can be liable in the first place. And these two things are, to me, very strongly connected, because if the practical conclusion is that it is not very easy to establish liability for a classification society, then of course it also means that the issue of limitation of liability is not so important. My second observation is that the doctoral candidate speaks very warmly for creating an international regime whereby the classification society would by law have the right to limit its liability, perhaps in the same way as ship owner and other defined entities. But in that evaluation, I find that the doctoral candidate has not so much emphasized factors that speak against limitation rights. And I would have hoped that the thesis would have been a bit more balanced in this respect, and that the doctoral candidate would have also taken up issues that speak against introducing limitation of liability for classification societies. So to me it's a bit imbalanced, and I have explained it further why I find it imbalanced in my written statement. But I would say that these are the two major critical observations I have made. Then I have more, shall we say, particular issues that I think I will not go into here, that can be read from the statement. And according to the instructions I have received, I have also included certain questions into my written statement. Now I ask the chair, shall I make the questions now, or can everybody read it from my statement? Shall I make the questions, or how do you want to organize it? Yes, well, I have 5 questions. I don't know how much time there is, because everybody else has issues as well. But my first additional question to what in addition to what my statement includes, my first question is that how does the doctoral candidate see the systematic approach that has been used in the thesis, and would it be possible to further develop the choices that have been made in this respect? That, for example, why was the lege ferenda, the proposals made first before there was research results on what is the present situation in law? And I would also like the doctoral candidate to answer the question if she found any doctrinal sources expressing a negative view on the right of classification societies to limit their liability automatically by law. And then I have 3 more questions in writing here. One further, which goes more to the particular than to the general structure, that why did the doctoral candidate find it so relevant to bring up or emphasize the role of the Hague rules and the Hague-Easby rules?
Mr. Honko, these questions will be answered later after all the reports have been read.
Okay, thank you. Yes. Well, I have nothing more to say. I just refer to my written statement otherwise. Thank you.
Thank you very much. Now I give the floor to Professor Makarova. Dear Chairwoman, or dear guests, the report on the thesis by Maria Rozhdestvenskaya is posted on the official website. So I will be very brief. First of all, I'm writing about the relevance of the topic. The contents, the structure of the thesis demonstrate that the candidate was able to reach all the objectives of the thesis. I also mentioned that the research findings are well grounded and well reasoned. They have scientific novelty. And I also highlight that the author referred to different international legal acts that regulate the functions of classification societies. The candidate refers to different court cases and so on. I also like that the author writes about public and private aspects of classification societies and writes also about statutory service and classification service. So in general, I must say that the thesis is scientifically valuable, which gives a solution to the issue in the field of international regulation of the limitation of liability of classification societies. However, I also have 3 critical remarks on the thesis. The first remark is similar to that one made by the chairwoman. I also highlight that the definition of the classification society, which we see in research finding number 2, is not quite accurate. The definition is given on pages 22 and 26. I think that the candidate should have given the type of business organization of classification societies. And I have some questions. Can classification societies be non-profit organizations if it is a commercial company? Then a classification survey is performed under the services contract. And is it possible to regard these actions in this respect as business operations? And can we speak in this regard that the liability is based on risk irrespective of the fault? My second question is as follows. Since classification societies perform classification and statutory services, is it possible to have a classification company which is a public company? My next remark, on pages 120, 121, the candidate writes about a force majeure, which is a ground for exemption from liability. However, the author does not interpret item 3 of Article 401 of the Russian Civil Code incorrectly. And my last remark, on page 167, the author refers to the old version of the Russian Civil Code. I think she should have agonized item 6 of Article 123.22, especially in terms of the subsidiary liability connected with the damage to two persons. I think that this can be justified by the fact that our civil code is changing all the time. But despite these critical remarks, I must say that the thesis is an independent scientific thesis which gives a solution to a very important issue in the area of law. And I must say that the thesis by Maria Rozhdestvenskaya complies with the major requirements set forth in order as of the 1st of September 2016 on procedure of granting academic degrees at St. Petersburg State University, and the candidate can be awarded the academic degree of the candidate of law. Thank you. Thank you very much. Now I give the floor to Valentina Talimonchik. Thank you for giving me the floor, and I'll try to be brief. So what I liked about this thesis, I used to think that international maritime law does not have any fields that are not unified among the countries, and the candidate was able to find a field where we do not see the unification of international legal acts. And the problem is how to unify the liability of classification societies. So how can we unify international legal acts in this area? And the solution provided by the candidate seems to be obvious and clear. Well, let's adopt an international legal act. But this solution is quite deep, because the thesis deals with at least 4 possible options which will allow us to unify different legal acts regarding the limitation of liability of classification societies. What instruments can we use here? So the author deals with more general issues, because the issue of liability in the international law can be solved in various ways. This regards to social and corporate responsibility, which has its own advantages and drawbacks. So this proposal given by the candidate seems to have been analyzed very thoroughly, and this solution is based on a deep analysis of legal acts. The main research finding seems to be very relevant. In general, I agree with the research findings, but still I have a couple of remarks. I cannot agree with the author's opinion presented on pages 40-43, which is as follows. Under the agreements with the flag state administrations on the delegation of powers to perform statutory surveys, classification societies are liable in contract. I think that agreements about the delegation of powers are close in nature to administrative agreements. The thesis gives a very thorough analysis of the international private law, but I think we should have used administrative law as well, because the theory of administrative agreement has been thoroughly examined in the legal doctrine, and the liability on delegating powers is not a private legal agreement. My next remark is as follows. I am not convinced by the reasoning given in the thesis on the following issue. The UN Convention on Jurisdictional Immunities of States and Their Properties 2004 states that classification societies can invoke immunity. The thesis author gives this statement after analyzing Article 2 of the Convention. But if we analyze the other provisions of the Convention, then we see a different picture. Probably they invoke immunity in some situations, but this statement that the Convention is used in terms of Article 2 is not enough. So that's why I wrote about the fact that this statement is not well reasoned or well argumented. But in general, I believe that the thesis complies with the order as of the 1st of September 2016, and the candidate can be awarded the academic degree of the candidate of law. Thank you very much for your report. Now I give the floor to Maria Rozhdestvenskaya.
Chairwoman and members of the Dissertation Board, first of all, I would like to thank you for your positive reviews, for your comments and remarks, which allowed me to specify my personal vision and allowed me to get a new perspective on some issues. As it was Mr. Professor Honke who provides a list of questions and addresses them directly, I'd like to start off by answering these questions. The first question was about the systematic approach I chose in my thesis. Well, this structure is defined by the tradition we have in the Russian Federation. That's the first thing. And secondly, it's predefined by the purpose of the research, because I aim to develop an international regulatory tool, and I refer to national legislation only in that way that it doesn't contradict international regulations. The second question that Mr. Honke asked is about possible negative view on the right of classification societies to limit their liability ex lege. There are such experts, and I have referred to their academic workings when compiling my dissertation. Among them is, for example, Anders Ulrich and his academic paper Underwriter's Perspective in the collection of papers Classification Societies, page 37, Marshall and Miller with the academic paper Liability of Classification Societies from the Perspective of United States Law, page 15. I would like to highlight, though, that the majority of experts whose viewpoints I dared share stand for the limitation of liability of classification societies. The next question concerned the Hague Rules. First of all, the Hague Rules were the first to provide the definition of the seaworthiness of a vessel, which was then borrowed by some states for their national legislation. Such countries are, for example, Russia and Germany. I make reference to the Hague Rules because they specify that it's the maritime operator who is held liable for the seaworthiness of a vessel. Hence, I make a conclusion that a classification society is not held liable for the seaworthiness of a vessel. Question 4, addressed by Professor Honke, was about Article 3.4 of the International Convention on Civil Liability for Oil Pollution Damage, and why does it apply to classification society only when they perform classification functions. I believe that the ex lege system of liability limitation in admiralty refers to them acting in public function, but rather to their performance in private function. Despite this close interrelation of classification societies and their public and private interest, here we mean their activity for the benefit of the ship owner. The fifth question was about the analysis of cases when the climate was targeting those who are to be liable, and about the ceiling limitations. The answer is yes. So when analyzing the case of the wreck with the passenger ferry Erika, according to the Swedish legislation and according to the Convention of Limitation of Liability for Maritime Claims, the special drawing rights originally amounted to 46,000. So then it was increased by 100,000 special drawing rights, which meant that for 2,000 passengers, the sum amounted to 200 million special drawing rights. However, according to the convention, the ceiling limitation accounted for 25 million special drawing rights, which definitely limited their liability. However, there are 1,200 plaintiffs, victims and their relatives from 14 countries which filed claims into the non-court against the Seaport Administration of Sweden and also against the Ship Building Yard Meereft and the Classification Society Bureau Veritas. So the reason for giving this little compensation for damages was due to the reason for those claims was due to the fact that classification societies are traditionally regarded as organizations having good financial standing. Talking about the terminology, so what's meant by non-legislative acts, I should have definitely used the term secondary legislation of the European Union. Professor Galenskaya supposes that I misused the term major or basic principles. I have to accept this remark. I should have used the term provisions. Then the next question about how to prove the absence of fault in terms of the Russian legislation. So I have to clear it up, clarify that according to the appropriate legislation, the fault is taken by the tortfeasor. As for Professor Makarova's statement, I should have really referred to a definite federal law. Professor Galenskaya, Shinkaretsky, and Makarova ask a question about the legal status of classification societies. I defined them through the term organization. The question is, what kind of organizations are meant? I mean organizations, bodies which have the status of a legal entity according to the national law. The specificity of their position is that on the one hand they participate in civil law relations and on the other hand they act on behalf of the states in public-private relations, and as I have stated in my research, they enjoy jurisdictional immunity when performing their public and private tasks. A classification society can be non-profit or commercial organizations. An example of a non-profit organization is a non-profit corporation, American Bureau of Shipping, or the Federal Autonomous Organization, Russian Maritime Register of Shipping, which was established by the Ministry of Transport of the Russian Federation and acts on behalf of the Russian Federation. I can further give examples of commercial organizations, for example, French Classification Society Bureau Veritas, which is a public company, or Norwegian Classification Society, DNVGL. Classification societies can have some other forms of incorporation, for example, as a public-private company, the Indian Register of Shipping or China Classification Society. Bureau Veritas is a commercial organization, so it conducts entrepreneurial activity, so it can refer to circumstances beyond reasonable control, which allows them to be exempt from liability. I have to accept the remark given by Professor Talimonchuk that the relations between maritime administration and classification societies fall under civil regulations, not fall under, civil relations, but should be regarded within administrative law. I can't accept the remark made by Professor Talimonchuk that I haven't focused in my dissertation on Clause 1, Article 16 of the Convention on the Jurisdictional Immunities of the States and their Property. I referred to this clause of the Convention when I compare certain provisions it contains with the law of the foreign state and property of the foreign state. The relevant pages are 150, 180, to be more precise, 181. Professor Galenskaya highlights that I focus mainly on classification societies which operate in the European Union and don't focus on other regional organizations. Professor Honka says that I do not provide any thorough comparative legal research concerning the regulation of the limitation of liability of on the national level. I have focused on the European Union because it's the only regional, it's the only organization that tries to somehow regulate the activity of classification societies. In the third chapter, I actually provide analysis of national legislation and case law of the USA. Professor Honka makes a remark that models can be different due to economical and technical capabilities of states. I don't believe it's really possible to provide an in-depth review of all possible legislations and the specific of legal frameworks and legal approaches of different countries. So for this reason, I didn't focus on the specifics of national regulation, but rather focused on the international regulation. According to international law, neither states or conglomerates of states have a right to establish their own individual regulation models. As Professor Honka remarks in his report, Anglo-American legal world is considered particularly important. Whether that status is always deserved in true substance and argumentation is another question. I suppose that this is a very important remark, considering the reality of modern life and the legal aspects in particular. Countries cannot monopolize legal frameworks and impose their own legal views. Any state can provide their view on the legal frameworks, but the choice is taken by international community. There was a question about CLC and LOMC conventions. As I write on page 280 of the dissertation, according to the CLC convention, the ship owner is entitled to recourse action to get the relevant damages. As for the Convention on Maritime Claims, it doesn't presuppose channeling liability. According to this convention, claims can be filed to the ship owner and to other persons that are entitled to limit their liability, such as freighters, vessel operators, insurers, and others. So another question is, are there any other preconditions to limit the performance and activity of classification societies? As I have mentioned, classification societies act to provide safety at sea, but we can't regard them as an organization that provides simply technical expertise. They have certain advantages because of their expertise and experience, which they apply world over which is especially important when it comes to maritime operations, because it's truly international in character. If the flag states would have to send their surveyors to other countries, they would face bureaucracy and significant financial expenditures. So classification societies are working for the benefit of the safety at sea. Classification societies can limit their liability through the norms of corporate law. Insurance coverage and the limitation of liability is more effective from the point of view of the compensation for victims of the incidents of the caused damage. Another argument is the fact that classification societies cannot classify all the vessels, and that's a potential danger because ship owners would be trying to find a low-class classification society which would accept such vessels that would affect safety at sea. Thank you very much for your attention. I hope I've managed to answer all your questions. I can't say that everyone is really satisfied with the answers to your questions. To be honest, I really can't accept that you called the question about major principles a simple terminological issue.
Difference in terms.
There is no really difference in terms. What we are talking about here makes the basis for international regulation. This is just a remark. I'm sorry, I must have worded my position wrongly. You can now take a seat. I would like to ask a question. So, is there anyone present here to take a floor and share their vision on the dissertation? So, as there is no one willing to take a floor, let's now take a 5-minute break.
I'm sorry, just a second. I must give the floor to the research advisor. I'm really sorry. Dear Chairwoman, dear members of the board, as I believe I must keep within 10 minutes, but I will take just very few minutes since I have submitted my report in the written form. I would like to say that I am happy with the thesis which Maria Rozhdestvenskaya has submitted, and her main objective was to prove the necessity for the unification of international regulation in the area of the limitation of liability of classification societies. And as one of the members of the board said, there were even 4 solutions to the issue. It means that the candidate realizes how difficult it is to reach a consensus among different states. Therefore, she proposes 4 different solutions to the issue. So today we're speaking about classification societies. And we all remember that they provide for the safety at sea. So Maria Rozhdestvenskaya was noble enough to speak about the justice and the balance of interests She says that classification societies should also be entitled to the limitation of liability. But this is not the only case here. Maria Rozhdestvenskaya was able to look at the issue from a wide angle. She speaks about the possibility to invoke the jurisdictional immunity, and she also speaks about public and private aspects. And this means that she has used a wider approach to the issue. And I also liked the defense procedure. I believe that the defense procedure should be a defense, and she was able to do that perfectly. Thank you. I would like to thank you. I'm really sorry. Now we must discuss the thesis, so we'll have a 5-minute break. And I would like to ask you to leave the room. So let's continue with the defense procedure. So this is the final stage of the defense procedure. During the 5-minute break, we discussed some issues with the members of the Dissertation Board. And now let's move on to the voting process. I'll start. So how do you vote? I vote for conferring the degree. How do you vote? I vote for conferring the academic degree. How do you vote?
I vote for.
How do you vote?
I vote for. Я за.
I vote for conferring the academic degree.
Yes, excuse me.
Professor Honka, how do you vote?
I vote for accepting it.
Now, thank you. I also vote for conferring the degree. So it's very easy to count. Out of 5 members of the Dissertation Board, 5 members voted for conferring the academic degree of the candidate of law. So this is a unanimous decision. Therefore, I think that the Dissertation Board has decided to grant the academic degree of the Academy of Law. I believe that you are very happy. Please, you can have a closing word. Dear Chairwoman, dear members of the Dissertation Board, and dear guests, I would like to thank the Chairwoman and the members of the Dissertation Board for the time invested in reading my thesis and for your interesting reports and remarks, which allowed me to clarify my provisions. I think that the limitation of liability of classification societies will allow us to distribute risks evenly. I also would like to thank all those who helped me with the thesis. First of all, I would like to say that I started to work on my thesis in St. Petersburg, Moscow Technical University under the supervision of Professor Boris Maslov, who is present today, and I would like to thank him personally. Besides, I would like to thank the Department of International Law and my research advisor, Professor Bachin. Thank you very much for your assistance and support. Besides, I would like to thank all the guests for your interest to my thesis. Thank you. Thank you very much. Now the panel session of the Dissertation Board is over. Dear colleagues, I thank you. I thank you for investing your time. We